Chang against the hospital administration and 2 others.
Shall it please, my lady? Lord, good morning. I'm Krishnadat Nimar, and I appear for the appellant. My co-counsel is Mr. Keshav Ramnath, and we are instructed by Mr. Harris Ramnath, who is directly behind us.
Thank you. Yes, review your submissions, please.
My Lord. Before I commence, my lords, my lady, may I humbly ask that I make a correction to my speaking notes.
Yes.
It is at paragraph O, starting from the 3rd line. In it, the sentence begins with, he said in his affidavit that he was confused.
I'm so sorry, which page are you on?
I am at paragraph O of my speaking notes.
The top of the second page of paragraph O. The speaking note doesn't have page numbers.
There is some,
he was confused.
yeah, there is some incorrect information there, my lords, if I may humbly ask that I correct it. In it I said that because the respondent's case was that the PSC, the Public Service Commission, represented to them, etc. That is not what the affidavit said. That is incorrect. The affidavit said, and I wish to put this in, he said in the affidavit that he was confused by the Public Service Commission's letter, which speaks of retiring him from the 9th of September 2002 and the letter dated 11th of March 2003 at page 131, coming from the second respondent, the permanent secretary.
What was the page number? Sorry.
The letter from the second respondent.
Yes. What was the electronic page number?
The letter is at page 128.
128.
No, sorry, no, 131. 131, which said that he has relinquished his post from the said 9th September 2002. This was his confusion. This is what I wanted to put in, my lord. I apologize for getting it wrong first time.
Thank you.
Thank you.
It is not normal for the board to receive speaking notes, and we don't normally seek them. But given that we have it in this case, we will obviously look at it. Thank you.
My lord, we did file submissions earlier and subsequently speaking notes.
Yes, well, as I say, we normally rely on your written submissions and your oral submissions rather than having an additional speaking note. We don't encourage it, but as I say, given that you've done it, we will look at that speaking note. You can assume in your presentation that the board has read the judgments below, the statement of facts and issues, and also your written cases. Thank you.
I thank you. May I be guided as to, now that my lord and my lady have read everything, can I proceed going in order, or do I take questions?
You present the case the way you wish to do it, and we will listen to you.
Now, my lord, just for context, the appellant, being a public servant, a special medical officer, sought to retire early. March, April of 2002, submitted an application, what he then believed was the proper way to do it. Submitted the application to the Public Service Commission. Unknowing to him, his salary was stopped by the respondent. Subsequently, he found out that he was sent on vacation leave, not knowing that he was on leave and had to resume duties. He raised an issue with it. They did not continue to pay him or revisit the decision, and then the matter was filed. In his matter, he claimed that the salary stoppage was unlawful. The respondent's case was that he had relinquished his post, and there was an issue around it as to he didn't report for duty, etc. But this need not trouble us because the High Court made a finding that the salary stoppage was unlawful. That decision was not appealed, and hence it shouldn't trouble us. The issue is, main issue rather, is what the court below, at the High Court, ought to have done, having ruled that this salary stoppage was unlawful. In that regard, I have attempted in my speaking notes very early to make certain suggestions. And at paragraph D, I identified what was the real issue in the matter. Whether the first respondent had acted reasonably in reaching his decision to stop the salary, and whether his continuing refusal to revoke the decision. These are the main issues that the court, at the High Court level, ought to have dealt with. Thereafter, in my speaking notes, I set certain chronology, which are basically information regarding which the appellant put into evidence. And for context, may I go back a bit? This action was filed in 2002, December. At the time, the only issue was the salary stoppage lawful or unlawful. 7 years later, in 2009, the appellant received a letter from the Public Service Commission, which basically said that we have decided to retire you with effect from 9 September 2002. Having received the letter, I think it is on November 30th, the appellant inquired by writing to the Public Service Commission, asking on what date was the decision to retire me was made. A reply came soon after that the decision was made on the 1st of October 2002. It is unfortunate that it took 7 years to notify the appellant of that decision. And may I humbly add to that in 2002, the date is in 2002, on the 8th of November, the Director of Public Administration, the DPA, who acts on behalf of the Public Service Commission, wrote to the respondent, to the Permanent Secretary, copied a letter from the appellant. The letter from the appellant was really a withdrawal of his application to retire early, and asked for comments. The Permanent Secretary replied by his letter of 11th March 2003, again at page 131.
What was the date?
11th of March 2003.
Thank you.
That the appellant, Dr. Chang, had relinquished his post. He gave certain reasons. It is even more confusing that in spite of being told by the permanent secretary that their position, his position is that the appellant had relinquished his post, and the Public Service Commission position was, we have retired him from the 1st of October, decision made on the 1st of October. This is short time, October to November. Even then, the Public Service Commission did not take the opportunity to notify both the respondents and to notify the appellant that you got it wrong. He had not relinquished his post. We had retired him.
When you say they had retired him, he wasn't getting any pension, though.
No pension.
So why do you say he was retired rather than that he just resigned his post by his letter?
Well, Milady, if I may, his application was to retire early. But it was a misconceived application, as we will learn a bit later, that he applied to go on the medical grounds, but he didn't submit any medical information, anything at all. It was a misconceived application.
But when you say they retired him, did they start giving him his pension early then, as from September?
Well, according to what happened subsequently, the pension was supposed to start at age 55.
Yes.
And it was age 52, this application was going on at age 52.
Yes.
Yes,
But-
they accept the retirement, but you don't get your pension until you hit the age of 55.
Well, that's what the
That's what
letter
they-
says.
Yes.
But as I've gone back, and the applicant recognizing that maybe he got some advice, whatever, that his application was misconceived and doomed to fail. He applied to go on medical grounds. He was not in any way ill in that he could not perform his duties. So he sought to withdraw the application. It is there when I believe that's where the confusion begins. Because his application to withdraw, I think, was dated 16th of September. The decision of the Public Service Commission to, let me say, approve that application, if they did that, was made on the 1st of October. On the 8th of November, the Public Service Commission wrote to the respondents, permanent secretary, asking for comments on the application to withdraw the retirement, or the letter to withdraw the retirement.
Yes.
This is confusing.
You mentioned that.
And then that is where the respondent informed the Public Service Commission that he had relinquished his post. Ironically, he has relinquished his post on the same day that he was retired. So the confusion is whether he was retired or whether he abandoned his job. The other add to the misfortune is that this retirement information came 7 years after the case was filed. At that time, it was basically a salary stoppage case. No retirement was an issue at that time. Because the appellant had a duty to be candid to the court. And of course, because of the civil proceeding rules, that the appellant's duty is to also assist the court in giving effect to the overriding objective. The letters were put into evidence by the appellant. There were 4 letters. The first is the retirement letter from the Public Service Commission of 13th of October 2009. The other letter was when the appellant asked the Public Service Commission, on what day did you make the decision to retire me? The third letter is coming from the Public Service Commission in answer to the appellant. We made the decision on the 1st of October 2002. And then the fourth letter, it came from the respondent, the permanent secretary, which the permanent secretary, who had filed his case in the court from 2002, saying basically that the appellant has relinquished his post. He is now in 2011 saying to the appellant by his letter, may I take a moment to get it, please? Yes, by his letter, I think it's 2011, am I right? July 2011.
Yes, 159.
Yes, July 2011. He is now saying that it is noted that the Public Service Commission has retired you from 2002, but he's saying this in 2011. And we need to process your pension. But he did not withdraw his case of the relinquishment of. He did not change his case. He didn't make any amendment. So we had a contest going on in the court that the appellant relinquished his post, which the respondent lost. He continued that in spite of knowing, at latest in 2011, that the Public Service Commission had retired Dr. Chang. Continued contesting the case on relinquishment up to 2015 before Justice Rampersad.
But even if he had relinquished his post, he'd still be entitled, presumably, to his pension when he got to age 55, wouldn't he? If you resign your post, you don't forfeit the pension that you've built up, I wouldn't have thought.
Well, milady, indeed, according to what the Public Service Commission did on its letter, it said that he will be entitled to pension from age 55. But our confusion was that we are in court with the respondent, who claimed that he had abandoned his job, relinquished his post, and a letter coming from a non-party in the case, the Public Service Commission, saying you're retired. This was the big confusion, really. And the contest was going on, and it was a serious contest. Witnesses were cross-examined, etc. So my humble view is that this case ought to have changed course, having a clash, a serious clash, where one body, a government body, independent body, is saying you're retired from a certain date. And the other body is saying, no, you have abandoned the job from the same date. This contest was going on in the court. It's very unfortunate. Even after the appellant put the evidence in, first at the Court of Appeal of the first appeal, there were two appeals with this matter. When we went before that Court of Appeal, we attempted to put the evidence at the first opportunity. The Court of Appeal allowed our appeal but dismissed the application. The second attempt was in 2015 before Justice Rampersad. He admitted the evidence. Even at that point in time and from then onwards, the respondent contested their case that you have abandoned your job. It is ironic that having lost that, or maybe in submissions, the respondents choose to use the retirement as a plan B and say, well, if we lose on abandonment, then you're retired from 2002. In my mind, this ought not to happen in a review court. In a review court, a respondent must face the challenge. Because we have, under the duty of candor, and like I said, you're very objective, put the evidence in to assist the court in managing the case. And if I may say apologetically, that the court did not take the opportunity to use that information in properly managing the case. The court did not, in my humble view, again apologetically, ask in its management of the case, the overriding objective, the respondent, that you need to take a side, you need to make a statement on this letter. Are you saying he's retired, or are you going to continue to say he's abandoned? You cannot have both. That, in my view, is where the court failed. In our submissions and in my speaking notes, I have taken the opportunity to show, and I intend to rely a lot on a case of the Court of Appeal, where Justice of Appeal Zamada gave concerning the CPR.
So your basic submissions is that you want us to interfere with a discretionary case management decision made by a lower court.
Yes, my lord, that is my humble view, and I know it may be an uphill battle. I also know that I said something in my speaking notes from a recent case of Dr. Deon Ryan and Ramcharan, where this court, I humbly asked to interfere in it, because where there's a denial of justice. And I am saying this is a...
And where would that ultimately lead to from your perspective, or your client's perspective, or Dr. Chang's perspective, I should say? I mean, what is he actually after here? Are we talking about salary that he believes he's entitled to, that he hasn't got? Are we talking about an element of pension that he thinks he hasn't got? What exactly is it that he's after?
I'm glad the Lord asked that, because I will get that to the end, really. The salary stoppage, as I've said, was unlawful, not appealed. The appellant, by the time the case tried, he was over the retirement compulsory age. He was 70 plus years, when retirement is 60 years. That his salary ought to have continued up to his retirement age compulsory. And then he would be entitled to his pension from retirement age 60.
So he's seeking the non-payment of salary
Non-payment of salary.
for, what's that, 7 years? 8 years, is it?
It would be about near 7 years.
So 8 years plus whatever the lessening of his salary is, of his pension is, by not having that salary. Is that right?
Well,
so there's a pension element.
Pension yet.
Pardon?
He has not received any pension yet. Because in his affidavit, he said, having received the letter from the permanent secretary asking for a certain document to process my pension, I did not comply because of my confusion whether I am retired or whether I am abandoned my job.
Right.
He said he did not comply. That the major issue is still under review.
So he's not received any pension?
No pension he has not received. So my humble view, to get it clear.
But even on your, even on the analysis you're putting forward, he would have been entitled to some pension. Is that not correct?
In my humble view, if the retirement is a good retirement, it should take effect from the date of notice, 2009, October 13, 2009. Though the decision was made in 2002, 1st of October, he was kept in the dark for 7 years.
So all this would have to be remitted, would it, on your submission, back to the lower courts to work out what he's been doing in the interim, how much salary he's been earning?
Yes, I would accept that his salary should be below.
So the ultimate point is you want us to overturn the discretionary decision, remit it back for these questions of what his loss actually is to be determined.
That's my humble submission, my lord.
But what he actually got, what he's actually had as a result of the High Court judge's decision is a decision that he was working, albeit not rostered, until the 9th of September, so he's entitled to his salary up to the 9th of September, and then he's entitled to 90 days retirement vacation. Not quite sure where that comes from, but that seems to be accepted. So that takes him up to the end of December. And then he has to wait until he's 55 to start drawing his pension. That is what the trial judge thought he was entitled to. Is that right?
That's what the trial judge, I think.
Right. And there was no appeal by the respondents against any of that?
Oh, not at all. There's no appeal from the respondent side.
No.
Yeah. Well, if I may enlarge upon that point a bit, that the vacation leave, what's it called, pre-retirement leave, it was vacation leave earned over the years and accumulated. It is not that it's a retirement stuff. It is leave that he would have normally earned over the years that was accumulated, 90 days.
Right.
So he was paid for that 90 days, and then the salary stopped. So even
Yes,
though
but was he also paid his full salary between May and the 9th of September?
well, that inclusive of the vacation leave.
No. The vacation leave was 90 days from the 9th of September. There was confusion before the trial judge as to whether that May to September period ought to be treated as incorporating somehow that 90 days vacation, and the trial judge said no, it shouldn't.
Oh, very well, Mary. I guess I remember. I'm thankful.
Yeah.
Yes, the trial judge held that he should be paid for the 90 days vacation because the respondent had forfeited that from him.
Yes.
Yes, I remember that. Yes. So that that would have taken him 3 months from the 9th of September.
Yeah.
Yes. And in my humble view, that if the retirement is good, because the respondent has lost its case on the relinquishment, if the retirement is good, it ought to take effect from the date of notice. Usually, if the decision is made on the 1st and you're notified on the 20th, no one troubles about the 20 days. But here it's 7 years. It's 7 years. So it ought not to. And the DPA had more than ample opportunity being jogged by the letter coming from the PS saying, the permanent secretary saying, that he had relinquished his post weeks later. He did not take the opportunity to notify the appellant that we have retired you. This case would have finished in 2004, 5, something like that. But the contest went on relinquishment right up to 2015. So my lord, my lady, there is this collision between two administrative bodies. One who, according to their case and according to the findings of the High Court, that the permanent secretary was the proper person to receive the application, to deal with it, the application to retire early, and to make a decision, approve or disapprove. That is the judgment of the High Court. So it is passing strange that this is a court finding that not appealed, and that the respondent subsequently took the point that, oh, no, you're retired. Retired by the Public Service Commission. So the finding of the court is the permanent secretary is the proper body to deal with that voluntary retirement. And then comes 7 years later, another body, the Public Service Commission, is saying we've retired. So as the appellant will be confused that the findings of the court, the evidence of the respondent is that the evidence coming from Ms. Shirley Bell, that the proper and current course for dealing with early retirement is in the circular SB 11 dated 5th of December 2000. That is a circular coming from the Public Service Commission to the permanent secretary, informing the permanent secretary that that I am not empowered to deal with voluntary retirements. You as head of the division must deal with it. He justified it in the circular by citing section 121 of the Constitution and the division of the Endel Thomas and the AG of the Privy Council. More than that, the Permanent Secretary has acted on that circular. He had received the application from Dr. Chang. He claimed that he had been processing it. He had asked for more certain information. And in the end, Ms. Bell says, we did not communicate the status of the application to Dr. Chang because he had relinquished his post. Ms. Bell said that. So, having acted on the circular as the proper person to deal with retirement, went as far as almost complete, asking for certain document. Then he stopped communicating. He says, we did not communicate, we did not notify him of the status because he relinquished his post. So, I find it very difficult. I find it extremely difficult to consider that in those circumstances, the Public Service Commission retirement is a proper retirement. It's not a party to this case. My humble view is the narrow issue here is not who is constitutionally the proper party to deal with voluntary retirement. That's not the issue, in my humble view. That's too broad an issue. The issue is, in this case, who is the proper party? The court made a finding that the Permanent Secretary, the head of the division, was in fact the proper party.
Where is that finding?
I can find it, Bishop. Okay. It will be in the judgment of Honorable Justice Ram Prasad. My Lord, if I may, at page 365 of my submissions, paragraph 4.
Sorry.
If I may read.
I'm terribly sorry. So,
read a few lines.
page what did you say?
Pardon me?
Page, did you say?
Page 365.
365.
At paragraph 4,
This is your written case.
and the heading is the findings of the High Court on orders made.
This is your written case. Yes.
Yeah, my submission, not my speaking note, my Lord.
Yes, yes.
If I may read a few lines, my Lord.
Just point out to us, please, the specific
Specifically,
passage.
yes,
where-
paragraph 4, in his written judgment, the trial judge at paragraph 49 set out the circular marked SB 11 in its entirety and thereafter made the following findings. Page 205 to 209. The practice in place at the time required Dr. Chang's application for early retirement be made to the PS, the Permanent Secretary, who could approve or deny same. At paragraph 50, page 206. This is the findings of the High Court.
Yes, it's a finding as to what the practice was. I don't think paragraph 50 is making any ruling on the correctness of the practice.
My Lord, so as I was saying, the narrow issue the issue of jurisdiction to deal with voluntary retirement is not at large in my humble view. To commence with, the Public Service Commission is not a party. The issue here is between the respondents and the appellant.
Paragraph 54, I think, is the one you're relying on, really, for your assertion, where he says that the perusal of the evidence suggests that the application ought to have been approved by the second respondent under the procedure.
Yes.
Yes.
So that was the finding of the High Court, that in this matter, on the basis of the evidence, on the basis of submissions on law, the proper person to deal with Dr. Chang's application was the permanent secretary, head of the division. So our confusion is the Public Service Commission retirement letter. This is where, the case went out of tune, if I may say. As I intimated earlier, this matter ought to have finished in the High Court if the case was managed properly. At the time when the evidence of the retirement letter was put in by the appellant, it was the correct time for the High Court under the overriding objective to deal with the matter, because there cannot be in a review court two inconsistent grounds. One, you have abandoned your job. Two, no, you're retired by a third party. This may happen in contract law, you might have an alternative, but not in a review court, in my humble view. In a review court is what was before the decision maker. So I went to some extent in my speaking notes, and I dealt with this issue of what was the respondent duty, or what the court ought to have done regarding the respondent duty. If I may wish to go to that, my lord, with your leave. If you know, please. It comments at paragraph CC of the speaking notes.
Sorry, paragraph?
Paragraph CC, double C.
Double C.
Double C.
He's only been more than 90 days. Yeah, but so he should get another 90.
My lord, it comments by saying that the respondent's duty was to assist the court to further the overriding objective of the CPR Part 1.3, which is fundamental to the system of justice post-CPR. The old rules, white book, has gone by the board. Post-CPR. But more than that, there has always been a duty of candor vested parties in a review court. So in my humble view, I submitted here that the permanent secretary, the second respondent, also had a duty to bring his own attention to consideration relevant to his division. And that division was that you have relinquished your job. That in light of having sight of the retirement letters from the Public Service Commission, he ought to have considered, on the one hand, this external body is saying he is retired, and I am saying you have abandoned the job. I need to focus as a permanent secretary and say, what do I do?
But weren't they dealing with two different time periods? The relinquishment of the job related to the period May to September, and whether he was entitled to his salary then, even though when he was rostered and attended at the hospital, he wouldn't do the work that was allotted to him. So that was whether he had abandoned his job then. But there was no issue that as from the 9th of September, he was no longer working at the hospital for whatever reason, isn't that?
Oh, no,
Weren't they dealing with two different time periods?
Well, yeah, from 9th of September, he was not paid.
No.
So there was no issue of working. From the time he had applied for his voluntary retirement, he was no longer rostered. And he was sent on his accumulated leave.
Well, the judge decided he hadn't actually been sent on.
Because it was his leave that was earned, but he was sent on leave. So not rostered, sent on leave, leave ends, and salary stops. So I was on the point of the respondent's duty. In a review court, there's a duty to be candid to the court, and I took the opportunity to refer to two cases at paragraph CC of my speaking notes, per Law J in RV Secretary of State for Education, ex parte London Borough of Southwark, 1995. And in this case, there was a duty to consult, in that case, other related bodies. And since the Public Service Commission is the body that appoints public servants, like Dr. Chang, since the respondent had passed the application to retire early, it was made through the respondent to the Public Service Commission. There was a duty to follow up. There was a duty to make inquiries. And 7 years, there was no inquiry. And there would have been reasons. And I'm saying the permanent secretary, having had decided in his mind that from 9 September 2009, he had relinquished his post, that would have blocked his mind from making an inquiry, because in his mind, he had abandoned his job. There was no issue of the application to retire bearing any fruit. His mind would have been shot, completely shot. In fact, he documented in writing on the 11th of March 2003 to the Public Service Commission, and saying his leave had expired, he did not resume duty, therefore he must be considered to have relinquished his post. In those circumstances, it is quite normal for a person not to make inquiry concerning an application to retire early, if the operative issue in his mind is abandonment of the job. And I'm saying this is where the respondent ought to have acted, didn't act, but it would be wrong to subsequently come and fall back and say, oh, you have retired, by the Public Service Commission. That plan B ought not to be available to the respondent. His case was, you have abandoned the job. Dr. Chang put in the letter of retirement out of his duty of candor, etc. But the respondent ought not to be allowed, and I feel very strong about this, to fall back on a retirement that was never in his mind, that is made by an outside party. I want to move on to paragraph DD. Briefly, as is well known, Ms. Bell was the only witness for both respondents. And she who gave evidence saying the processing of Dr. Chang's application was going on, we asked for certain information, etc. They're all there. And then at the end, having abandoned his job, relinquished his post, the retirement application got fall off the board, and that we did not inform him of his status. In fact, they did not even inform him that you have abandoned your job. He learned that my papers being filed in the court.
Can I just ask you, I mean, you've made certain submissions regarding the duty on the respondent, what they should have done. Did you at any time submit to the court that the resolution of these confusions would only be assisted if the PSC was joined. Did you actually ask for the PSC to be joined?
Oh, we did not do that, my lord, and I can give you the reason. The case in the court was about relinquishment, and the letters that came from the Public Service Commission concerning retirement confused the appellant. That I am in the court against a respondent who said I have abandoned my job, and now I'm getting this letter from another party, and this is the confusion I'm in. But I'm going to put it into the court and let the court make use of whatever it is. Because at that point in time, the Public Service Commission, who claimed to have retired Dr. Chang, could not have assisted the court in any way regarding the respondent's case. Their case was, you have relinquished your post. But out of the duty of candor, like I said, Dr. Chang put it to the court. Let the court make use of it. If, in my humble view, if a case management was done and it had become an issue, I put that into my speaking notes, that the retirement letter could have come into play. At the time it was put in, it could not have come into play because the issue was relinquishment of the job.
Well, that's
But
your paragraph U, isn't it? It's your paragraph U.
Yeah, I think it
Your
is.
speaking note.
That it could have come into play. If the case management was done and the issue was identified, that this is an issue in which the court need to probe. If the issue was identified under Part 25(1) of the CPR, that if the issue was identified, of course, either party could have taken the opportunity to join the PSC. Because it would have been more appropriate for the respondent to do it because it was clashing in direct opposition to its case. The respondent's case was, you abandoned the job, and this is saying you're retired. It is in direct opposition to its own case. But I am saying either party would have taken the opportunity. Maybe lawyers could have agreed on it, who's going to do it, or joint application. But it could have come into play if the issue was identified. But unfortunately, if you look at the sequence of events, the letters, the fresh evidence was admitted. The cross-examination of Dr. Chang took place. Directions were given to file submissions and file reply.
But you did in your written case before Justice Ramsad, you did in fact address the PSC's letters.
Yeah,
And you said that they were obviously false.
indeed,
So it's not as if the issue
I wish to take the opportunity to, whilst I didn't have total control of the case at that time, but nonetheless,
No, I say you, I mean...
I'm going to give you an explanation, my lord.
Yes.
You see, my lord, the letter says, the second letter, when Dr. Chang asked the commission, when did you decide to retire me? It said, we have decided on the 1st of October. But on the 8th of November, same year, the DPA, mouthpiece of the PSC commission, wrote to the respondent saying, hey, Dr. Chang has submitted a withdrawal of his application to retire. I want your comments. Why would he be asking the respondent a month and 8 days later, having made the decision to retire? You have already retired. Why do you need the comments from the respondent saying, well, he has sought to withdraw his application? In my humble view, even the trial judge spoke of it mildly. He said there were suspicious timelines.
Yes, but...
So there is some suspicion there, my lord.
Yes, but I think the point that the respondents are taking against you is that you chose to address this in a certain way or not you personally, but your team chose to address this in a certain way in the written submissions at page 177 or in the electronic bundle, and you chose in effect to say, not you, your team, you chose to say that these things were simply false. So you were impugning the letter of the PSC.
My own view, my lord, it was a little too strong. The words were a bit too strong, although there are sufficient.
Yeah, but I'm not really interested in the nature of the case made. It's the point that your team chose to address the PSC in a letter in a certain way in 177 and 178 of the electronic bundle. So it wasn't as if the issue of the letter wasn't before the court. You had put it in process quite properly, and in fact you fought to have it, or your team fought to have it admitted against the opposition of the respondents, and it was admitted.
It was admitted.
Yes, and then that is how you responded to its presence in the process at page 177.
My lord, if I may, there was in the submission at the Court of Appeal, the impression the appellant lawyers had, including myself, was that the letters were admitted de bene esse. That was the impression, the oral direction, oral admission. So not when we got the actual paper, it was just admitted, not admitted de bene esse, but submissions were made as though it was de bene esse. So we don't know whether you're right, but we will have to go with the writing. We're not going to oppose that, of course. It's what the writing says, you know.
You're now seeking in your speaking note to argue that the letters were inadmissible, which is a difficult position to take when it was you who sought to introduce them against the opposition of the respondent. And they were admitted, and there was no challenge in the court below to their admissibility. I don't see how we can possibly make a finding that the letters were inadmissible.
My lord, I agree with you to some extent, but I need to, sorry, I need to submit that whilst it was admitted, it ought to have been admitted de bene esse, because in my speaking notes I said that at that time it had no relevance to the issue that was on trial.
Well, it did, in the sense that if you were right that Dr. Chang had not relinquished his post in, say, May by declining to do what he was asked to do when he arrived at the hospital, then, as the judge found, he was still employed over that time. Then the question is, well, was there any other end date between May and now in which his salary was properly stopped? And what the judge found was, well, yes, there was a reason for stopping his salary as from September, which was that he'd retired. And if you wanted to say he hadn't retired, then you needed to challenge that decision.
Well, that was the High Court position, but we have taken the position that, and I wish to go back to my lord, earlier point, that having put the evidence in, well, because of the duty of candor, as I mentioned earlier, but it could not have come into play on the triable issue of relinquishment of the post. It's either you retire or you relinquish. It couldn't assist in any way.
Well, the thing is, it did come into play. I take you back to your own written submissions at 177 and 178, where you addressed it, and you said that it was. You said if you look up the paragraph 29 of your submissions, this issue requires consideration of these letters. A perusal of these would reveal the obvious falsity contained in the DPA's letter of 13th October 2009. This letter was written to the appellant over 7 years post the withdrawal of his application, and it reveals that the Permanent Secretary and Miss Bell's involvement in a plot to cover their inefficiencies and to set up the applicant's abandonment of his job. So you're basically saying that the DPA's position was false.
Very strong word, my lord, I agree. Very strong. But I wish, as I indicated, that submissions were made on it. It might have been, I do not recollect very clearly, regarding the rebuttal of the presumption of regularity, that the court held that, my recollection is that the letter from the DPA saying you're retired, the appellant is retired, was presumed to have been regularly made. What was said in the submission, I think, I do not recollect clearly, was to show there is some reason here by which it can be rebutted. There's a rebuttal of the regularly made presumption. But it was coming on a bit too strong in my view.
But the fact is you were seeking to address the allegation that there had been an acceptance of your request to retire early, and that was an issue in the case, and neither party sought to bring in the PSC to answer the allegation that the whole thing had been cooked up to hide inefficiencies in the administration.
Well, I wouldn't want to use those words, my lord, but it would appear that is the impression that was given in the submission. But mostly I think it is because in an effort to rebut the presumption of regularity, submissions were made as to why the court ought not to presume it was regularly done. And those were one of the matters that were put before the court. There were other matters, of course, that I made it in both my speaking notes and my submission, that there was a representation from the Public Service Commission to the respondents, which I talk about the circular 5th December 2000, in which the Public Service Commission informed the respondents that I am not empowered to deal with voluntary retirement because of Endel Thomas and the AG, because of the Constitution, and that is now for you to deal with. So this, in my humble view, would go to the rebuttal, because you cannot on the one hand represent something, and then on the other hand, retire the applicant. First you're saying, I'm not in charge, I don't have the power to do it, and then now you're saying, I'm doing it.
Well, if the PSC had been joined, there may have been a discussion, a debate about what the legal effect, if any, of that circular was, given the wording of the regulations and the statute. But that debate wasn't had because the PSC wasn't joined to the proceeding.
Definitely, I agree. I agree that if the PSA was joined, it could have happened. And I already spoke of why the appellant did not take the opportunity to join, because it didn't come as an issue, it wasn't identified by the court, it's a CPR issue.
But I think,
either party could have done it.
but speaking for myself, I'm struggling with that submission because it seems to me it plainly was an issue in the court, and you should therefore, the duty was on you to join the PSC. You chose not to make that submission. It's too late now to come round surely and say, oh well, that's something the court could have done. You didn't suggest it to the court. And it's no, speaking for myself, I cannot see your answer satisfactorily to be oh, well, it wasn't an issue. It seems to me it plainly was an issue.
My Lord, I would have agreed totally if we were operating under the old rules.
On what,
Under
sorry?
the old rules, the former CPR. We took the position that this is a matter now under the new rules.
Yes. I mean, the nub of your, as I understand it, of your grievance on this appeal is at paragraph U of your speaking note. If I can just take you to it, it's on the electronic version of it that I've got, it's on page 7. You say, the trial judge, having formed the opinion that the PSC's letter could likely touch and concern the reliefs you were seeking, was required to, and then you list a series of what I might call case management steps that would have led to the joinder of the PSC. And at the moment, I don't really understand your appeal as a criticism of the judge having formed that opinion, but rather it's a criticism of the judge not then having taken of his own motion the proactive case management steps to give effect to the consequences of that opinion. Have I understood it correctly?
I see your point, my Lord, but it begins with the starting point, the chain. If the evidence was put in, the issue on the part 25.1 of identifying what new issues are now coming up with this letter. And from the judge's judgment, it appeared to us very clear that he had formed the opinion at some time that this was relevant and pertinent and you know, they need to be joined in PSC. But at the time it was put in, it was post-CPR, meaning at the time when the court over an objective will identify the issues, and that it was put in under the duty of candor, under the duty of assisting the court in the over an objective. It was not seen as though...
But if the effect of putting in that evidence led the judge to conclude it gave rise to issues between you and the PSC, which couldn't properly be determined without my presence, then the parties, you either needed to get the PSC joined, or the judge, you say, should have done it of his own motion.
No, I'm saying not having identified the issues, having gotten to the stage where all case management conferences are over, the judge had the power, having recognized that it was an issue, having recognized that the PSC could be useful in this matter, the judge had the power to join the, I think it's part 26, 26.1.
The judge's perception that there was an issue between you and the PSC that needed to be sorted out, for which purpose it could only be sorted out if they were a party in a judicial review context, only arose during, as I understand it, the final hearing of your judicial review application. Let's call it the trial. It didn't arise at an earlier stage in the judge's eye, because it was only once he started to entertain the trial that he had to consider the relevance of these letters which you put before him. But those letters were before your team throughout.
Well, from 2009. October, November 2009.
Yes, but I mean, we're now talking about when was the final
2015. 2015.
Yeah, I mean, 6 years earlier.
6 years.
And it's currently striking me as quite a tall order to say, well, this has all gone wrong because in the middle of the trial, when it became apparent that these issues were being raised, looking at your written case in the trial, which we've seen, he should have stopped the trial, directed the joinder of the PSC, and had it resumed at some later date when they've got their tackling in order, rather than you should have had the PSC there from the outset.
Well, my Lord,
on your own application at an earlier case.
My Lord, if I may, as I indicated earlier, that would have been something that would have considered and surely would have done to join the PSC if we were operating under the old rules. In a post-CPR matter, we are led to believe, and we agree, that it is a court-driven system.
Yes, but it doesn't absolve
And
the
that
party.
having put the evidence in, that the court will now identify issues.
Yes.
We will now talk to the other lawyers, agree to make a joint application to join them, or make a single application. This was the mood.
I understand that, but it doesn't absolve a party from the duty of working out, if he wants certain relief from the court, who he needs to sue or join as defendants or as parties in order to be able to get that relief.
Well, Lord, I totally agree. And as I said, it could have been done. But being post-CPR, it was not given that careful thought one.
It depends on how you decided you wanted to pursue your claim. Your claim was for lost salary from
2002.
From 2002 to the present day, on the basis that there was no reason why there should be any cut-off. As you say, the debate was whether you had Dr. Chang had relinquished his post or not. But once the retirement letter emerges, then it's up to you to say, or up to your client to decide, do I want to press for 7 years or whatever of salary, or do I accept that actually the cut-off date beyond which I'm not entitled to anything is now going to be the 9th of September, and so I'll only get my salary up to then, plus my 90 days. And it's your client's decision whether he's going to cut back his claim to that. And if he is, then fine, the decision from the PSC can stand. But if he wants to pursue the claim for salary to today, he has to overcome that new obstacle. And that's not a decision that the judge can't foist on your client the potential costs of bringing the PSC in, unless your client does want to challenge that decision. But did your client make it clear that he did want to challenge that decision?
I mean, like I indicated earlier, I am in agreement, except that it being a post-CPR matter, this matter was filed under the old rules and then converted to the new rules, CPR. It was felt at the time wrongly or rightly.
But the CPR emphasis on judicial case management is, generally speaking, case management up until the beginning of the trial. I'm not saying he has no case management duty thereafter, but he's entitled to assume that, save insofar as a case management issue has been put before the court at some interim stage, the parties, the claimant for relief, will have worked out himself who he needs to have before the court to get that relief. The parties are not entitled just to come to the court and say, well, I want this relief. Judge, you tell me who I need to sue. I mean, the CPR don't go that.
Lord, like I said, I appreciate it, and I agree, except as I indicated, because of the issues that were in the court, because of the duty of candor that they were put in all honesty,
Yeah.
that it was felt that in the old rules the lawyer would have dealt with, shall I bring the PSC? In the new rules, this will only become relevant, this will only become into play if the court do its work under Part 25(1), identify the new issue that will arise from these new letters, and then one party or the other would have taken the initiative to go forward.
But you did identify the issue in your written pleadings, not you, your team's written pleadings before the judge. Can I refer you, please, to electronic bundle at page 179, paragraph 35 of your written pleadings? And it reads, it is submitted that the PSC's decision to grant permission to the applicant was made without jurisdiction and is null void and of no effect. As the PSC is the applicant's employer, the court is invited to quash the decision, even though the PSC is not a party in this matter. So you are making an application to quash a decision of the PSC without bringing them in as a party. So it isn't as if the judge, after you made submissions, was thinking about the matter and was thinking, oh, this letter may be a complete answer. You were facing up to it in your team's submissions and were saying that the PSC's decision was null and void.
My view is it's gone a little too far. Asking to quash it, the division in the absence of a party is a non-starter in my view. But this is in the submission, like I said, it would have most likely been regarding the presumption of regularity.
Pardon?
The presumption of regularity. But it had gone a little too far in my view.
But my difficulty isn't whether or not, in the rather strange circumstances of the letter coming 7 years later, there is any force in the presumption of regularity. My concern is you faced up to the issue in this paragraph and you invited the court to treat as null and void the PSC's decision. So this was something that was up front in the case at the time before anyone was speaking to the judge. Here are your written submissions.
I mean, also there was one of the issues was who was the proper party to deal with the application. Because the respondent evidence was that the head of the division, the permanent secretary, was the proper party. Ms. Bell did put in the circular of 2000, December 5th, and she said this is the proper and current practice of dealing with voluntary retirement. So it can be, and I may say it can be, that the case here is that the permanent secretary is the proper party. And we have a letter saying, coming from the Public Service Commission, who claimed not to be the proper party by the circular, is approving the retirement. So it was more of a jurisdictional issue. And like I said, the narrow point here in this matter is not whether the Public Service Commission was empowered to deal with Dr. Chang's application. The issue here is a narrow issue, that on the court finding that the permanent secretary was the proper party to deal with the application, what do we make of the retirement letter coming from the Public Service Commission? Because let's say, agree that the Public Service Commission had retired Dr. Chang, it will be totally inconsistent with the findings of the court that the permanent secretary was the proper party to deal with it, to approve or disapprove of it. It will be an inconsistent, on the one hand, saying that the PSC is the proper party when the court found that the permanent secretary was the proper party. It would be, in my humble view, going out on a limb. My lords, if I may proceed, please.
Please do.
Yes, I did at paragraph EE. I made the point that upon the respondents having sight of the retirement letter post-2009. It was a time when it ought to have made a decision. This is a review matter. We are claiming as respondents that we have stopped Dr. Chang's salary because he has abandoned his job. Here it is, we are confronted with a retirement from the letter from the Public Service Commission. Are we going to adopt this decision? Are we going to oppose it? Are we going to continue to do our case on abandonment? This is a review court. And that, again, I wish to emphasize that the respondent, as well as the appellant, has a duty to assist the court to give effect of the overriding objective, which includes Part 25, or how the court deal with it. In fact, I went a bit further in the submission to say, in the absence of the respondent taking a position that we are going to continue to do our case on relinquishment abandonment, in the absence of that, the court ought to have put it to them. You cannot keep your feet in two boats. You cannot, on the one hand, say he had relinquished the post from a certain day, and in the next breath say, oh no, he had been retired on the same day. You can't do that to a review court. The court ought to have asked them to disclose what their position will be. Again, it's another procedural matter that had it been done, the appellant would have been in a position to know what he's up against. Is he up against abandonment or is he up against retirement?
I can see that, but as I say, you did take a position on this in paragraph 35. I mean, you've got to face up to the fact that you invited the court to quash the PSC's decision.
Well, like I said, it went a bit too far. My humble view is no court will quash a decision in the absence of the maker of the decision.
Right.
No court will do that.
But I mean, you nakedly invited the court to do exactly that, and in the absence of the PSC.
Well, it was done, and it's there.
But what it shows is that this didn't come as a horrible shock to your side only when they got the judge's judgment, but it was something that was in your side's contemplation as something that perhaps needed to be done even before a hearing opened before the judge, because it's in your written case.
My Lord, I think it did come as a shock, and maybe what you're seeing in the paragraph 35 is the response of a person who is shocked.
But this is written before judgment, surely. This is the...
I mean, please look at the document. You've got the papers.
No, I mean when the letter came in 2009, the retirement letter. That was a shock.
Yeah, but what we're talking
That was a shock.
At the outset of the trial, your team, not you, your team produced a written submission which contained this paragraph inviting the court to treat the PSC's decision as null and void in their absence.
I think it's fair to say it wasn't at the outset of the trial. It was a closing submission.
So I do apologise. A closing submission.
I agree with that. It's there. I already said that I do not think it could have been sustained because it was against a non-party. But it must have, as I indicated, to show the court that the presumption of regularity on which it wishes to rely on, there is some evidence here, there is some reasoning here that the presumption ought not to be upheld. That was the intent, I suppose. It may have gone a bit too far, maybe the language is a bit too strong.
So your case put at its highest, I suppose, is that if the respondent wanted to introduce what you've called a Plan B, to say, well, even if he didn't relinquish his post at the latest by 9th of September, he was no longer working for us, and so our failure to pay him a salary then was perfectly lawful, that it was up to them to establish the validity of the PSC decision.
The respondent's case was relinquishment. It is Dr.
Yes.
Chang who put the evidence in of retirement.
But what the judge rejected that case. He said there was no relinquishment, but he said, nonetheless, he was retired on the night, or he left his job on the 9th of September when his application to resign was accepted. So that then created a cut-off date for your client's salary. So it turned out that it was the respondent who was relying on that decision to cut back the scope of your claim, the time period covered by your salary claim.
I see Mallory's point, but as I indicated earlier, there cannot have been in a review court, and I hope I'm not wrong, 2 reasons for one, stoppage of salary because of retirement from the same day, or stoppage of salary because of relinquishment on the same date. In a review court, this ought not to happen. A party to the case need to know what I'm up against. And I said there was more than ample opportunity from the time the appellant seek to put the letter in at the Court of Appeal, which was about 2011 or thereabout, 2012, for the respondent to take a side. If his position was, well, we did stop his salary for a certain reason, but from now that we've seen the retirement, we will take this side. The appellant would have known what he's up against, and this case might have been completed long ago.
I mean, my Lord has drawn attention to the paragraph in your closing submission that the decision of the PSC was null and void. That is a recognition by you that that point is alive, that in effect they are relying on that. Because you're recognizing it, aren't you, as a decision which otherwise blocks your claim.
Well, my Lord, I have already explained that it was going a bit too far, one.
Yes,
The court did not give it any recognition at the trial, at the High Court. The court did not even, as I say, make any long comment on it. It was unsustainable. The language might have been too strong. But at the end of the day, it was an attempt to convince the court that the retirement decision, the presumption of regularity of that decision ought not to be sustained because of these, because of the letter of 8 November 2002 coming from the Public Service Commission asking the respondent to comment on the withdrawal of the application to retire when it had already decided 6 weeks before that they have retired Dr. Chang. Why would the Public Service Commission need a comment when you already dealt with the matter and retired him? The next step is to notify him.
Those are the very matters which would require the presence of the PSC in the proceedings in order to determine.
Well, my Lord, if the Public Service Commission decided on the 1st of October 2002 to retire Dr. Chang, it's a decision that it made because it felt it had the power to do so. The next step would have been to notify the respondents and notify Dr. Chang that we have made a decision to retire him. Dr. Chang, you're retired. The respondents, well, he should no longer be in the payroll. But 6 weeks after making the decision, without notifying any of these people, he is now asking the permanent secretary that Dr. Chang has written to withdraw his application to retire. I need to have your comments.
Yes, but I can well see you may say this is a case where the presumption of regularity might be under threat by the rather strange facts on which you understandably found. But isn't that all the more reason for allowing the PSC to answer the allegations that have been made against them?
Appreciate it. We've gone to this already, that because it was a post-CPR matter, it was dealt in a particular way with the expectation that it's a court-driven system, that the issues will be identified, somebody will make the decision to join, not to join. It was mainly because of post-CPR matter, there was certain expectation of the court to deal with this matter in a certain way. And if the issues were identified, matters would have flowed smoothly from there. Like I said, my own view is, if this was under the old rules, there would have been an entirely different consideration. And I took the opportunity in my written submission to speak of the new rules. And
was there in fact a case management conference of this judicial review application, but earlier than the trial? One's expectation is that case management would ordinarily take place at the point where a decision is made to give permission for judicial review, rather than have a separate conference, unless it was a complicated. The chronology, I don't think, really helps. We just know that there was the previous appeal, and then these proceedings got going, and then there was a trial before Mr. Justice Rampersad.
yeah, Millard, I do not recall, when I look at the notes at the matter before Justice Rampersad, I did not see in it, my recollection, that there is any note of a case management conference.
Yeah.
But at the point when the letters were admitted into evidence, that might have been the point at which everyone would turn their mind to the significance of those and whether any further directions were necessary as a result of those now being in evidence.
It should have, because my recollection is the application to put in the fresh evidence before Justice Rampersad was March of 2015. At that point, like I said, consideration of a case management matter conference ought to have happened. But it is unfortunate that I'm looking in hindsight, that being a CPR matter, like I said, there was certain expectations. And having read the preface to the CPR by Chief Justice Honorable Sharma, practitioners who are on the button will get the impression that it is the court-driven system that will raise these issues, and attorneys will follow and ask questions and take direction. Because we are told that this is a new dispensation altogether. The old rules were the old rules. The overriding objective of Part 1 and 25 and so on now give the court a certain power to take control, to take charge, and to, it's a court-driven system. So it is unfortunate that in hindsight we are seeing it this way, but at the time it was seen as, well, the court will determine this matter by pointing out the issues, we'll take a cue from that, we'll know how to go forward. It didn't happen. What we got was direction for submissions, and submissions were made.
But it looks as if you're coming to this court asking us exceptionally to overrule a discretionary decision of a lower court, that is, not to join the PSC, in a situation where you did have the opportunity to ask for the PSC to be joined, and you didn't take that opportunity and I think as it's now been made clear, it was certainly an issue which at the time did require and was appreciated that the PSC had to be brought in order to resolve it. So it's a bit of a tall order, isn't it, to ask us to step in at this stage.
Well, I will agree with that if my submission on the admissibility, the essay, when does the letter come into play, if it did come into play, if my submission is not accepted, then I will accept my lords. But I did make submissions on, now that the court had the benefit of the letter of fresh evidence, it was for the court to make use of it. At the time, the issue that was triable was not retirement, relinquishment. That it will come into play only when the respondent discloses that we are no longer pursuing relinquishment, then we are dealing with retirement. It could not have both, not in a review court. And that is where, in the failure of the respondent to do it, the court ought to have put the respondent on the spot and said, you are saying you stop his salary because he abandoned his job. I have before me a letter saying from the PSA he is retired. What do you say? The court should have put the respondent in that position to make a decision. It couldn't have both.
Do we have in the bundle the closing submissions of the respondent?
Yes.
Yes.
At the High Court, Milan?
Yes, I think we
Yes,
do.
it will be there. It will be there.
I think
We're at
it's
183.
182, isn't it?
Yes.
It is there.
And what was their position there?
So I think we see it at 185, paragraphs 2 to 5.
And my lords, my lady, without interrupting, on page 187, the very last paragraph.
We will notice in the submission that the respondents did have the benefit of both defenses, if I may say. It argued that Dr. Chang has relinquished his post, and it also argued that he is retired. This is what I'm saying in the judgment. And I've been saying the respondent ought not to be allowed to say he is retired from the 9th of September 2002, but also he has abandoned his job from the same date.
Why can't they run both? I mean, it looks as if at the time, back in 2002, they relied on relinquishment of post. But why can't they say, well, even if we're wrong about that, the decision of the PSC is that Dr. Chang has ceased to hold office?
I'm saying this is a review court, and the High Court position is to review what was before the maker of the decision, the respondent. What was before him? What consideration was given? What was relevant? What was not relevant in determining to stop the salary? That is the focus of the High Court. The High Court is not going to make its own decision, so to speak. The High Court wants to know, did you give proper consideration or did you not in stopping the salary?
I mean, the PSC decision is one that would cut across any decision that was taken by the respondents, as I understand it. If that decision was within their power and was properly taken, its effect was that Dr. Chang ceased to hold office. And there's nothing the respondents could do about that.
Well, I've been saying a lot that upon having sight of the retirement letter, the respondent could have and ought to have done, I'm saying, to decide whether it is going to continue its case, press on with its case on relinquishment. Because the issue here, my lord, is this, that the date of retirement is the same day as the date of relinquishment. Can it really be, in practice, that a person can be retired or alternatively abandon a job on the same date? This is impractical in my view. So it was necessary, having had sight of the letter, to take a position.
But wasn't there, before this letter came out, wasn't there a case that he had relinquished his post much earlier than the 9th of September?
Yes, he had relinquished. Their case was he had been from the April, whatever.
Yeah.
But they lost.
Yes.
Yeah, they lost. So it pressed on with that relinquishment, but fall back on retirement.
But it's not the same. They weren't saying that he had relinquished on the 9th of September, and also by coincidence he was retired on the 9th of September. They said he had relinquished much earlier, but their fallback was if he hadn't relinquished then he was certainly retired on the 9th of September.
But Milady appreciated, but the salary stoppage was from the same 9th of September.
Yes.
And the retirement is the same date, abandonment is the same date. And I'm saying, practically it can't be both. This can never happen in practice. It's a matter of common sense in my view, that either you're retired, or either you're abandoned. Either you're alive or you're dead. There's no in between.
Well, with the oddity in this case is that the initial case of the respondents was that you had relinquished post, and then when you put the PSC letter in, they resisted it coming in.
They resisted
But it was allowed in, and ultimately, as we see from their closing submissions, it was founded on. So the judge had, at the end of the trial, they had your team saying at paragraph 35 that the PSC decision was a nullity and should be held as such, although the PSC wasn't there, and the respondent saying it's valid and it's a complete answer to the case. That was the circumstance the judge faced when he wrote his judgment.
Well, the respondent position was, if I remember clearly, it is presumed to have been regularly made, because the PSC was not in the matter. Their position was the PSC is not empowered to deal with this retirement in the first place. That was the respondent position.
Not in this case.
Second position is it objected to letters coming into evidence, that it was not before the decision maker, if I remember correctly. The third position now is to fall back on it. And I'm saying, I've repeated this, that the respondent had to, on the basis of part 1(3) of the various objective, a duty to take a position to tell the court, well, we have come with relinquishment, now we have this letter, this is our position. And in the absence of that, the court ought to have directed them to disclose the position.
The respondents made the position very clear in July. Is it July 2015? The judge's judgment was in December. So that even if the form of the respondent's case, where they seem to be taking the retirement point as their main point, not just a fallback, came as a surprise in July, the judge, I mean, surely the judge was faced with one side saying it's an invalid decision, but we don't need to join them to get you to say so, Judge. The other side saying, yes, it is, but it's a valid decision. And you're the party seeking judicial review. I mean, you had months in which to go back and say, well, now we know that's the case they're advancing, we need to join the PSC.
Well, like I said, I appreciate it, and in hindsight, I might have done differently if I were. But I said earlier, having settled into the CPR, knowing the court-driven system, knowing the court will identify the issues. The issue really here was this, Millard, that the appellant was contesting a relinquishment, abandonment. And having received it, like I say, it was a shock, but nonetheless, it was felt necessary to put it before the court and let the court-driven, process deal with it, and the parties will see how to manage their affairs later. It is unfortunate that it's in hindsight. It's unfortunate. But at the end of the day, my lord, the major issue, as we look at it CPR-wise, that there's an issue of dealing with case justly, identifying the issues, ensuring that one party do not get an advantage over the other party. And there was advantage here, where you have the respondent having a plan A and a plan B. This is not what should happen in a review court. Plan A is relinquishment, the plan B is retirement. All this, in my humble view, are procedural matters. But in CPR-driven litigation, we are of the view that these matters ought to have been dealt with. And like I say, it is unfortunate now that we are looking in hindsight. My lord, if I may, I know I don't have much time, so I wish to add a bit to my submission, a short bit. At paragraph, before paragraph, page. At page 381, my lord, of my submission, but my submission, not in speaking notes, page 381, at paragraph 53, I cited Real-Time Systems Limited, a judgment of the Court of Appeal of Trinidad and Tobago, division by Honorable Justice of the Appeal, Jamada. That judgment, is at page 840 in the bottle.
Thank you.
840?
Yes, but I know I don't have much time, so I just want to identify the paragraphs. That I wish to rely on that judgment on paragraph 8, 9, 10, 21 and 22, 23. It's a short paragraph.
8, 9, 10, 21 to 23.
8, 9, 10, 21 to 23.
In a nutshell, what does that establish?
Basically, Justice Jamada was talking about court-driven litigation. The issue in this matter was whether the court ought to have allowed an amendment, I think. And the High Court ruled that case management conference is closed and we don't have the power to do it, so no amendment. Justice Jamada wrote up this judgment and allowed the appeal. And in this most of the judgment deals with the CPR and the court's role in litigation. And in it, he was pointing out, he also cited, as I did in my submissions, from the forward of the CJ Chief Justice Sharma of the CPR. And he was speaking of the change in the litigation culture in Trinidad and Tobago and the court's role, and etc. And I think this can be very useful in my submissions. As I indicated, I don't have much time, but if I do have the time, I can go to the paragraph, my lord.
Yes, he's talking about the critical importance of the case management conference at the heart of the new procedural code. That seems to be his point.
Yeah.
But I also learned that Justice Jamada and another judge wrote a book recently on the role of the judge in CPR recently, which is very useful to us practitioners. The unfortunate part is that when we ingest and digest this and we have certain expectations, and when you go to the court, it is not fulfilled, and then we have to probably go back to get the mind to think pre-CPR. That is a challenge for people my age, really. What time I have? My Lord, I am told I have 5 minutes. Are there any areas you would wish me to assist before my time run out?
Thank you very much. If there's nothing you wish to add, that's fine.
Well, I think I did add this piece that I intended to add.
You have another 9 minutes if you so desire. But if you've completed your submission, that is fine.
My Lord, I wish to talk briefly on the presumption of regularity and good administration. I think I dealt with these matters somewhat extensively in my speaking notes.
Yes.
I did do it in my submission.
That's paragraph JJ and following.
Yeah, then following. And assuming that the court do not agree with me on my earlier submission, the issue will be, if I should succeed in the presumption of regularity, then the letter of retirement will no longer be a useful and viable tool of the other side. And I think there's a strong case on the presumption of regularity, because I took the opportunity to it's a pretty lengthy one. Yet to incorporate in it certain paragraphs from our submission at the Court of Appeal. In it, we attempted to show that the laws in Trinidad and Tobago and the laws in the UK have a slight difference. That the question of a court refusing to give certain relief under the Judicial Review Act can only happen where there is delay. If there was no delay, a court is not empowered to refuse relief. That's one of the points I made. And the other point I gave, if I may say, sufficient support why the presumption of regularity ought not to happen, because of the various things, some of which I dealt with already, but I gave A, B, C, D, E a certain reason, and then I touched briefly on this point. And this is a very important point. There were two documents before the court, both presumed to be regularly made. One of which, the first one, was the circular memorandum that the Public Service Commission wrote to the respondents, 5th of December 2000. In that circular, the Public Service Commission informed the respondents that it was not empowered to deal with voluntary retirements. Because of Endel Thomas and the Constitution, etc. And that the head of division must now deal with it. That document also carries the presumption of regularity. Now we are saying the letter of retirement coming from the Public Service Commission is also presumed to be regularly made. there's a head-on crash. On the one hand, the Commission is saying, I am not empowered to deal with voluntary retirement. And on the other hand, it's saying, I have retired Dr. Chang, who applied to retire voluntarily. This is a collision, serious collision. There are other reasons, and one of which we touched on earlier is the one which I said there was some strong language when there is some doubt, some suspicion over the timelines of the DPA letter to the permanent secretary and back and forth. And then we also need to look at that not only there was the circular memorandum from the PS, from the Public Service Commission to the respondents acknowledged and acted upon it. It processed the appellant's retirement application. It asked the appellant for certain documents. It decided that he had abandoned his job, so we are not going to write him about this application anymore. Ms. Bell says very clearly in her affidavit that we did not inform the appellant of the status of his application to retire early because he had relinquished his post. So on the one hand, we are having regularity of the retirement decision, regularity of the inconsistency, of the, I don't have the power. The PSC is saying, I don't have the power. This, in my humble view, is more than sufficient to rebut the presumption of regularity. And if that presumption is rebutted, the letter is no longer a useful tool upon which my learned friend could rely upon.
I wonder about that step in your logic.
Well, I'm saying, if it is not presumed to be relevant,
I can well see that if the PSC were a party to the proceedings, there would be a number of questions that might be asked, and the judge hinted at that when he referred to the timelines and so on. But in the absence of the PSC, on what basis could the court properly treat the decision intimated in 2009 as invalid?
Well, I'm saying, if the presumption of regularity is rebutted, then there's the reverse, that it is not presumed to have been regularly made. If it is not presumed to have been regularly made, then how can someone rely on something that is not regular, something not presumed to be regular?
Well, the absence of a presumption may simply leave it as an issue which needs to be sorted out between the relevant parties. In this case, the client and the PSC.
Oh, I understand, but I'm saying it is no longer a viable tool. Because if on the one hand the presumption is rebutted, the respondents can no longer rely viably on it.
Well, it's that leap of logic that I am questioning.
It may be a Caribbean logic, Milan. And then I went on to deal with good administration. And it started that, and this is where the regularity also comes in, that given that there is an interest in good administration, which is independent of the interests of individuals, how do the court see these two inconsistent pieces of correspondence from the Public Service Commission? One saying, I am not empowered to deal with retirement, voluntary retirement, and the other saying, I have dealt with Dr. Chang voluntary retirement application and I retired him. What will good administration say about this? So I've dealt with it in my submissions, and maybe later I may take the opportunity to rebut what my colleague is going to present. So I know I'm running out of time a lot. If there's any question?
You have completed your time. Thank you very much, Mr. Neal.
Thank you very much, Lord, my lady, and thank you very much.
The board will now adjourn to consider its position and will return shortly. Peregrine Benson, we do not need to hear from you. Thank you very much.
Thank you, my lords, my lady.
The board is grateful to council for their submissions and also to those who have assisted council in preparing this appeal. The board will take time to consider their judgment.